Good afternoon, DAR members. Give us just a moment. We're working through some technical issues that have been discovered at the last second. So give us just a second. All right, we're getting some messages just so everybody is aware that our Zoom room maxed out because of everyone that signed up. So if you have people contacting you, we are working on that. But right now it's maxed out at 300. So we are hopefully going to get that resolved in the next few minutes, but we're going to get right into it as this is being recorded so we can get started. I'm Wes Stefanik. I'm the Chief Executive Officer of the Delaware Association of Realtors. So thank you all for joining us this afternoon. This is one of our highest registered events recently, so that's great to hear. We do have some notes to point out. This is being recorded, like I just said. So please have patience for us when we send that out. Give us a second. Our screens are messing up. All right, there we go. I think we're ready now. All right, so like I said, we are recording the session. It will be sent out in a day or two for everybody to use and to see and to follow up on. If you have questions during the presentation today, please submit them in the chat box to the name that says questions. That'll go right to me. We will be taking questions at the end of each form that has gone over, and we'll go from there. We're not going to be able to answer all the questions today, so keep that in mind, but your first point of contact always is your broker. So always go to them first. And if there are further questions, you can provide comments on our website. If you go to delawarerealtor.com/member-forms, there is a form submission tool where you can provide any of your comments, as well as in the future suggestions on any other DAR forms. If you're in a transaction and you think something should be changed, always feel free to submit those, and our forms committee will review them. So with that, I'm going to turn it right over to Mr. Bruce Plummer, the chair of the forms committee, and Mr. Andy Taylor, our association's legal counsel.
Good afternoon, everyone. Welcome to our meeting today. I will first off mention those that are on the forms committee. There are 6 people on the forms committee, 2 from each county. In Sussex County, it's myself and Camilla Conlon. In Newcastle County, it's R.T. Christopher and John Ford. And in Kent County, it's Bobby Slagle and Tom Burns. The 6 of us make up the committee, together with Andy Taylor, our legal counsel. Wes is often in on the meetings. Matt is always on the meetings, and I don't know what we do without him. He has been working extra overtime with us. We have been working feverishly to keep up with this NAR proposed settlement and chasing this buyer broker compensation and new forms. We've been collecting forms from all across the country. We've been having several meetings, I think at least 14 that I know of so far this year. Some of them, the last couple, have been 4 hours in duration. So there's been a lot of work going into this. Today, we're going to unroll or reveal the new buyer agency agreement. And we're going to go over the new listing agreement. Both these agreements were rolled out and introduced to the managers and brokers last Thursday. They're being introduced to the entire membership today. And next Friday, which is June the 28th, they will become the DAR form. They will replace the current form. In addition to that, we'll be hosting another meeting in a couple of weeks where we will be rolling out a new agreement of sale. The new agreement of sale has been completed, and we've got 1 or 2 finishing touches to put on it. It'll be introduced in the next 2 or 3 weeks, and we will have a similar meeting for brokers managers, followed a week later with a meeting for the entire membership. I know a lot of this is new, so as Wes said, if you've got questions, talk to your broker. I know that some of the local associations will be offering training. Some companies will be offering training. A lot of this is newer information. I understand that. I want to first off start off by introducing our legal counsel, Andy Taylor, and he'll give you a little bit of background on how we got to where we are and why all this is necessary.
Thank you, Bruce. Share my screen here. Give you some of the legal background from where we are. Okay, so try to give you how we got here as far as the background with this and also some Delaware perspective on this, so you can better understand what we've been dealing with the Forms Committee with the changes needed to be made to the forms. Also, we had some fun with the forms in that we would think we were done with the form. And then a new interpretation or a new guideline or something new would come down as far as how the NAR settlement was being interpreted, or we thought it might be interpreted, and we'd have to go back to a form or a section of a form that we thought we were done with and rework it. So it's been a lot of excitement working on the forms. So the proposed settlement was on March 15th, 2024, which would settle 4 of the pending antitrust cases. We heard it was settled in the wee hours of the morning. The NAR directors were not aware of it. The NAR directors did not need to, or were not given the opportunity to vote on it. So we were as surprised as you were. And so we need to understand all this, though. It's not just antitrust law. It has to be looked at in the context of antitrust law, MLS rules, agency law, the Delaware Licensing Act, the rules and regulations of the Delaware Real Estate Commission, and the use of the CIS, the Consumer Information Statement in Delaware. I think it's good that NAR settled, after the initial shock we had with our phones all blowing up that morning. But then we came to the realization, okay, we can work with this. And it would have taken another couple of years for the cases to work through the appeal process. There was the weight of the copycat antitrust cases that were being filed, all the uncertainty of that. And so we've all been trying to deal with this since March 15th. So a good site you've probably already been on, but facts.realtor, and that's not limited to just realtor members, facts.realtor. NAR continues to update and to continue to update their FAQ section of that. So we can figure this out for Delaware. An unknown that we have at this point is, will the United States Department of Justice file what's called a statement of interest? That's like a brief. Will they file a statement of interest about the proposed settlement in the case? But we have studied that as a Forms Committee. We think even if they did submit a statement of interest, we know what they said in another case, and we think we could deal with that. A little more background. Remember the basic meaning of the word broker. You're making a market in something. In your case, you're making a market in real estate. So as agents, you create the marketplace for real estate in Delaware. And there was what I think is a very significant study that was just updated by the Bright MLS August of 2023, called their On MLS study. This is something you may want to read if you haven't already, to be able to explain it to your sellers. And the conclusion of this study is that between 2019 and the first quarter of 2023, comparable homes sold on the MLS sold for 17.5% more than comparable homes sold without being listed on the MLS. So it shows, again, part of the value that you bring to the transaction. And agents, so I think a good vocabulary for it is that agents are paid from the transaction. You're paid from that value that you help create. It's always cracked me up a little bit through the years. Who pays the commission? Well, you ask a seller's paying, they're paying. You ask a buyer, the buyer says, well, it's my money on the table, so I'm paying it. So anyway, that to me is just kind of a red herring to even think about that. So what was the basic of the allegation for the antitrust violation? And that was that by agreeing to follow the NAR clear cooperation and compensation rules, requiring an offer of cooperation in the MLS along with an offer of compensation, which could be as low as $1 or $0. The allegation was that agreeing to follow that rule was price fixing. The judge in the case instructed the jury that if they found there was that rule and there was agreement to follow that rule, it was what they call per se price fixing. There was also allegations that it was a tying arrangement. And the judge then was not allowing the jury to use what's called rule of reason analysis under antitrust law, which is where NAR had very good analysis, very good arguments for why the clear cooperation and compensation rules were good for consumers and good for the competitive marketplace. They didn't even really get to that point with a jury. So as you know, the clear cooperation policy required brokers to submit listings to the MLS within 1 business day of marketing the property to the public. The Bright rules, as you're aware, have now been changed. NAR's compensation rule required there to be the compensation. So these rules are part of what's changing. Now, in the basic allegation in a similar case, in Northern District of Illinois Federal Court, the Morrell case, Bright MLS was not a defendant in that case, but were identified as an unnamed co-conspirator. So looking at that case, it is instructive to us. And the allegation from that complaint is that defendants' conspiracy centered around the adoption and implementation of the rule that requires all brokers to make that blanket unilateral, a non-negotiable offer of buyer broker compensation when listing on the MLS. So Morrell, this case, was one of the 4 that are included in the proposed settlement. So that's good. So if the proposed settlement is approved by the court, then Bright MLS is released from the case, including the Morrell case. So this is good for us in Delaware. So the allegations, even more simply stated, are that the sellers paid more in commission money than they would have otherwise if it wasn't for these rules. The seller paid commission to money to buyer's agents who were working against the seller's interest. That's debatable as to what, but brokers should compensate their agent. Buyers should compensate their agent. And the sellers did not understand that commissions were negotiable, and buyer's agents should not have been saying their services were free, which actually was stopped by rule in 2022 anyway. Certain companies settled before the jury verdict. There's a good 1-page summary of one of the company's settlement terms. If you haven't seen that, send me an email. I'll send it to you. Let's look a little more historical perspective in Delaware. Remember that a participant in the Bright MLS does not need to be a realtor, but needs to be a real estate licensee. And we should all be careful to try to use the vocabulary correctly that way. Licensees, anyone who's licensed through the state of Delaware Real Estate Commission as a real estate salesperson or broker, whereas then they've chosen to join the National Association of Realtors, Delaware Association of Realtors, your local association, then you've chosen to be a realtor. So let's try to use our vocabulary carefully that way. Not all licensees, as we know, are realtors. And so the fact that you did not need to be a realtor to be a participant in the MLS, this was also true for the prior MLS, which was called Trend, and that is the way it was spelled. And this came about from a lawsuit in Pennsylvania from 2002. A little more historical context for you, because this is somewhat back to the future. Prior to January 93, the MLS had a blanket unilateral offer of seller subagency, not a mention of buyer agent compensation. So then when buyer agency started to become more common, then to represent a buyer, you needed to contact the listing agent, reject the offer of seller subagency, ask if cooperation was offered to buyer's agents, ask if any compensation was being offered to buyer's agents, and then have that documented on a compensation form, and then finally be able to set up your home tour and go out and show homes. So in 93, the MLS definition changed. It was no longer the blanket unilateral offer of seller subagency. It became subagency optional with the offer of cooperation to seller subagents, buyer's agents, or both. So this is why it's a little bit of back to the future, because the offer of compensation, if there is one, to a buyer's agent, will no longer be on the MLS. But we'll talk more about some practical aspects of how to handle this as well. There's some ways that it can be handled quite well. So even though the proposed settlement does not go into effect until after court approval, assuming they approve it in November, the practice changes and everything else are going into effect August 17th. And so compensation offers are moved off of the MLS if they exist at all. The written agreements for MLS participants acting for buyers that before you tour homes, you need to have a buyer, some type of agreement with the buyer. NAR is paying certain settlement money, and NAR continues to deny any wrongdoing. The class for us locally, this is homes listed on the Bright MLS, March 6, 2015, through the date of class notice, which is going to be that August 17th date. So there will be postcards mailed out to members of the public. You might receive some phone calls from people you've worked with in the past. And so you could explain to them, there's websites they can look at to find out more about the case. And they'll probably decide to stay a member of the class, but they could choose to opt out of the class settlement agreement and pursue their own individual case with their own legal counsel. The settlement agreement, assuming it's approved, includes release of liability for NAR members who are members as of July 2024, and then all state and local realtor associations, all association-owned MLSs, so this includes Bright, and brokerages with a certain sales volume, and so pretty much most being covered. Brokerages above the 2 billion can join. Many other companies then have continued to join. So an unknown, as I mentioned, we have at this point is, will the Department of Justice file a statement of interest commenting on the proposed settlement? We have not heard if they will file this. We'll know by late September or early October, but we need to comply. We need to get the practice changes in by the August 17th. So implementing this in Delaware, let's look at more of the specifics. The practice changes, if you'd like to read the settlement agreement, begin on page 27, paragraph 58, eliminate and prohibit any requirements that listing brokers or sellers must make offers of compensation to buyers brokers or other buyer representatives, either directly or through buyers. Eliminate and prohibit any requirement that those offers would be blanket, unconditional, or unilateral. And so more of these practice changes prohibiting realtors and MLS participants and brokers, agents, and sellers from making offers of compensation on the MLS to buyers, brokers, or either directly or through buyers, disclosing on the MLS listing broker compensation or total broker compensation, and the offers of compensation then to a buyer's agent may not be anywhere on the MLS, nowhere on the MLS, not in the agent's remarks, not as part of the seller's disclosure form if that's posted on the MLS. Now, interestingly, brokers, listing brokers, can show offers of compensation on that broker's website, but only for that broker's listings and not having that populated out to other sites. So the broker just showing there can show offers of compensation to buyers agents on that broker's website, only for that broker's listings. Also an agreement that you cannot create, facilitate, or support commission information being on other aggregators' websites. So we've heard of some people saying, oh, we can set up this site and everybody just send your information here and it'll all be here in this one place. No, don't do that. Don't participate in that. That would it's not allowed under the settlement. And you need to comply with all this in order to be covered by the release of liability. As I mentioned before, agents must have a written agreement with the buyers prior to showing the buyer any properties. This, I think, is going to be one of the most difficult things implementing in just getting the member of the public to slow down. Oh, can you meet me at 3 o'clock? Just saw this listing. Well, yeah, I'm sorry, who are you? Well, I need to explain some things to you. Well, no, just see me at 3 o'clock at the property. Well, it may be used to do that, but you need to have some type of agreement. So I think that's going to be one of the hardest things, getting that potential buyer, hey, wait a minute, slow down. I'd like to meet with you, at least a half hour, be able to explain some things to you. By rules, by law, we need to have an agreement in place. Well, I'm not going to sign. Well, would you just give me a half hour of your time? Or we can do it by Zoom. Can we do a Zoom at 2 o'clock and then I'll meet you at the property at 3? Oh, we can do that. Yeah, we can do that. So that's going to be a little bit, I think, of trying to just get that member of the public to slow down a little bit. Realize you're a professional. You need to explain about your services. You need to explain about the agreements. We note that it does not need to be any particular type of agreement with the buyer. The forms offered by DIR are offered as a member service. You're not required to use these forms we're going over today, offered as a member service. Your broker, your company will be looking at them. Your company will be having company policy on what forms are used and how they're implemented. As you know, the Delaware licensing act already requires that there must be a written buyer agency agreement if it's an exclusive arrangement with the buyer or if the buyer is agreeing to pay compensation. But now you need some type of buyer agreement with each buyer, any buyer, before you tour them properties. So more from the settlement agreement, it's important to read all these paragraphs together. We're requiring that all MLS participants working with the buyer enter into a written agreement before the buyer tours any homes. I've talked about that. And to the extent that you will receive compensation from any source, the agreement must specify and conspicuously disclose the amount or rate of compensation you will receive, no matter how that will be determined. The amount of compensation reflected must be objectively ascertainable and may not be open-ended. For example, you cannot say buyer broker compensation will be whatever amount the seller is offering to the buyer. Next element to this, the MLS participant may not receive compensation for brokerage services from any source that exceeds the amount or rate agreed to in the agreement with the buyer. Remember that buyer agency agreements and the compensation, those can be amended, but you cannot force a buyer to amend it. The buyer is the one that could agree to that or not agree to an amendment to that going forward. So as you've been doing, you have a listing appointment with your potential seller, having that interview with a potential seller. You should now be having, if you haven't already, be doing the same kind of thing with a potential buyer, have a buyer counseling session, explaining about cooperation and explaining that buyers, they have an agreement that's going to state whatever your company policy is as far as compensation with that buyer's agent. But remember, a buyer can make an offer to a seller with a contingency for the seller to agree to pay compensation to the buyer's agent. And so the compensation to the buyer's agent then becomes a point of negotiation, just like other terms of the agreement of sale. And this does not violate the NAR Code of Ethics, because this is not the buyer's agent trying to use the offer to change the compensation offered by the listing agent. This is the buyer himself, herself. They're making the offer to the seller with a clause in there for the seller to agree to pay compensation to the buyer's agent or not. And so this is part of what you'll be explaining to the buyer. And in my view, a seller receiving an offer, you'll help them just look at the bottom line. You're comparing offers. Okay, this offer's here, I'm paying some compensation. This offer's here, but I'm not paying compensation to a buyer's agent. So you'll be helping a seller to understand in comparing offers what their net would be, just like you're helping them with net sheets now. A buyer, same thing with a buyer. They just need to know, they're making an offer. Is the seller agreeing to pay some compensation to their buyer's agent or not? It's a point of negotiation. Again, the buyer's looking at what's their bottom line for what they're paying. Is that all going to the seller and the seller's paying some compensation to their agent? Or is the sales price going to the seller and then the buyer's paying their buyer's agent? So again, it's just the total amount that the buyer would be paying that you'll be helping them calculate. So as I mentioned, I hope you can get buyers to take some time with you in the counseling session, buyer counseling session that you would have, review your company forms, review the Delaware CIS so they understand about our statutory agency in Delaware. I think it's good to give both sellers and buyers the fair housing brochures. NAR has some good ones of those. And the Delaware Real Estate Commission is considering adding some language to the CIS to help from the Delaware Real Estate Commission, an authority in real estate in Delaware, protecting the general public, to say that broker and agent compensation is not set by law and is fully negotiable. There's not a quote standard commission. You, meaning the member of the public, should discuss compensation and the scope of your services to be provided for compensation with your real estate agent early in the process. Brokers can set their own compensation fees based on what services are offered and their business model in the competitive marketplace. And to protect your interest, it's recommended you enter into a written agency agreement outlining your real estate agent's duties as well as your rights and responsibilities. Your company will have company policies to determine their own policies for services offered to sellers and buyers and their compensation schedules. You, as brokerages and as individual agents, will be finding ways. You're explaining about your value proposition, as I mentioned, the value you're bringing to the transaction. And within companies, there can be a full list, full service menu of services. It could be a menu of services model or a full brokerage services model, and could be compensation based on the different levels of services. And so those are things you will discuss within your company. You cannot be discussing those type of things with agents outside your company because you don't want to be accused of another conspiracy of conspiring to do business in a particular way or conspiring to charge in a particular way. So your individual value proposition, there are a couple tools if you haven't seen them, NAR, to get you to start thinking about this. You know, don't just hand out these brochures. You're not going to be doing all 179 ways that they think realtors help their clients and 105 more ways that realtors help their buyer clients. Don't just hand those out and say you do everything in there. Just use that as a tool to help you develop your own value proposition. Supervision and guidance by the brokers and managers of the office is even more important now as we evolve. It will all play out in the competitive marketplace. I think this will lead to an even higher level of professionalism within the real estate profession. I think this is good for you and good for members of the public. Remember, of course, to always comply with fair housing laws, federal laws, Delaware laws, and try to make sure your sellers are not using some of these new rules or ways of doing business to illegally discriminate. And so I really think we have some advantages in Delaware. There was a U.S. Supreme Court Justice, Louis Brandeis, who said that states are laboratories of democracy. I think in Delaware, we have a real advantage to work with this. Some advantages are that we're small. The Delaware attorneys represent buyers in real estate transactions, so they have that independent representation by their own real estate counsel. The Licensing Act in Delaware already requires a duty of confidentiality with that member of the public upon first contact. And I think the single agent dual agency should remain as a choice in Delaware for the consumer with an understanding of the pros and cons. As you know, it's dual agency defined by our statute for what the agent must do and may do. The CIS explains all about this. The CIS allows the consumer to easily opt out of the dual agency if they want to. And that could be for an individual property, or it could be for their entire brokerage relationship. And so what about a buyer who says, I just can't pay. I just can't pay you. Well, a buyer could proceed unrepresented. A listing agent would explain the CIS. The buyer would initial that the listing agent is only representing the seller, or the buyer could ask for that listing agent to be a dual agent and agree to that. And if the seller has not opted out of the dual agency, then the agent could proceed on that presumed consent to the dual agency as defined in the Delaware Licensing Act. Remember, in Delaware, the term of the buyer representation agreement can be for as short or as long as the buyers and the agent want to be. So it could be for a day, a week, a month, several months, depending on what the broker and the buyer agree to. It can be limited to representation for just one property, a short list of properties. All properties could be wide open geographically, could be limited geographically, flexibility for that. The Delaware Licensing Act, Section 2935, already includes a duty to cooperate. I'm not going to go over all that right now. I also encourage you to look at Section 2930 on compensation within the Licensing Act. And I will mention this duty to cooperate. When this was worked on by me in 2005, 2006, this was carefully reviewed with the assistance of the United States Department of Justice Antitrust Division to make sure that the wording we were putting into this duty to cooperate, in their view, complied with antitrust laws. So I feel that was, fortuitous. That we're already set up for allowing brokerage models on a menu for services and a charge for services, menu for services type of brokerage model, if that's what the company wants to offer. So we will see how this all comes out in the competitive marketplace. Everyone else like us is figuring this out. So lenders are figuring this out. You may be aware that the VA recently released a temporary policy update taking effect August 10th that would allow VA buyers to pay their buyer's agent. There's other cases that have been pending as well, copycat cases. And again, we'll see how all this works, but I think this can work well in Delaware. We can work with it. As Bruce said, keep your comments coming to the Forms Committee. I know from participating in their meetings, they read every single one of those comments. They carefully consider them. They debate them. They get input. Things go to the board of directors for further input and change on the form. So it's a process that I think works well. Again, we're small. It can work out well that way. Keep those comments coming. So that's all your legal background for where we are. As I said, it continues to evolve. And so it wouldn't surprise me, particularly if the U.S. Department of Justice puts in a statement of interest on this NAR settlement, that we wouldn't be back here in a couple months explaining further changes. So we'll keep working with it. Bruce?
Thank you, Andy. I'm going to go ahead and share my screen. And the first thing I'm going to share is the new buyer agency agreement. So if you've not been following this, a lot of that background may sound confusing or difficult. And really, folks, this is probably not as confusing and not as difficult to deal with as it may sound. I want to take our buyer/tenant agency representation agreement and go through it with you. Now, right now we have a buyer agency agreement, but it's quite old. It was adopted some time ago. And it really is problematic in some ways in the broker compensation part. So it is just being totally replaced. I'm not going to show you the changes between the old form and the new form. Throw the old form in the trash. This is the new form. And I'm going to go through it. It starts off, it says exclusive. And this is an exclusive agreement. I'll talk about that in a second. Buyer/tenant agency representation agreement. It can be used for buyer representation or representing a tenant. You could use it for either or both. And we have started with the term brokerage organization. That's because in our rules and regulations under definitions, the brokerage organization is the company that's being retained or hired. But we don't want to use that term throughout this document everywhere. So the brokerage organization, you put the firm name there, and then going through the document, the rest of the document, we'll just refer to that entity as the broker. That'll be the broker. Technically, under the definitions, broker in our rules and regulations is the broker, what we used to call the broker of record. But now we're going to refer to organization as the broker. Now, in section number 1, you'll remember we did away with calling these paragraphs. They're now sections. Section number 1, it starts off, effect of an exclusive buyer-tenant agency representation agreement. Let me delete some of this. Hereafter referred to as agreement. So we're advising the client that this is an exclusive agreement. Now, the Forms Committee talked about making it so it could be an open agreement, a non-exclusive agreement, or exclusive. We've elected just to go right now with an exclusive agreement, just like our exclusive listing agreement that sellers sign. If you want to doctor it up and make it a non-exclusive, you can do that. Or we may create a non-exclusive form in the future, but this is an exclusive form the way it stands right now. You'll see it says highlighted in yellow. I'm pointing out the things highlighted in yellow here. This is an exclusive agreement, and client may not enter into a buyer/tenant agency representation agreement with another real estate brokerage organization during the term of this agreement unless otherwise noted in section 18. So it's exclusive. If you're retaining me as your agent, I'm your agent. Don't go using somebody else. Now, it does say, unless noted in section 18, because this It could be that you're hiring me to represent you in Sussex County and somebody else to represent you in Newcastle County to find properties there. It could be you're retaining broker A to represent you in a sale where you're purchasing a property, and broker B to represent you in finding a rental property. So you could, but you can't. We have an ethical duty per the Code of Ethics to ensure that a client, before they sign an exclusive agreement with us, is not bound exclusively to another person offering the same services at that time. So we're making them aware this is exclusive the way it stands right now. And the last highlighted section there says, for example, we'll give them an example. If the client purchases or leases a property on their own without broker's assistance, such as through an open house, for sale by owner, or with the assistance of another agent, upon settlement or possession, the client would still owe broker the compensation described in Section 9. So this is an exclusive agreement. You want to make sure your parties understand that. Now, we go down to Section 2, and we're going to call this acquisition. In the old buyer agreement, we would have a territory, if you would. You would say in the counties of, I'm going to represent you in trying to find a home to purchase in Kent County, we'll say. We have put counties of, but we put a default there. If you leave the line blank, it will be statewide. So a client might put, I'm hiring you or retaining you for your services to represent me in Sussex County or Newcastle County. If they put nothing, it's statewide. It also, that starts off that sentence, it says, in acquiring real property, hereafter referred to as property, for purchase and or lease, check all applicable. So most of the time, a person is not going to be hiring you as a buyer's agent and a tenant's agent at the same time. They could, but this form could be used for buyers or for tenants, either one, to retain you as their agent, and you would check the appropriate one or both if applicable. So then we go to expiration, section number 3. I think it used to be called termination. You'll see in all of our new documents that we now are calling it expiration. And by the way, we're unrolling 2 documents today. We're unrolling a new agreement of sale soon. All this all ties together and works very neatly. So we have our new expiration date, which you can fill in. And then you'll see highlighted, it says broker and broker's sole and absolute discretion may terminate this agreement at any time and effective immediately in the event client provides any false information, misrepresents any fact to the broker or any third party, or otherwise breaches the agreement. So it's got an expiration date. You'll see it's also after this in section 4, it's got a cancellation provision. But if our buyer client or tenant client misrepresents stuff to us or isn't doing what they're supposed to, we as the brokers can terminate the agreement immediately. Section number 4, I don't have it highlighted, but it's the cancellation provision. And some folks have asked, well, why do we have a cancellation provision? Well, I think it seems reasonable if you're going to ask somebody to sign an exclusive agreement with you, you have an expiration, but suppose they want to cancel early, just like we do in our listing agreement. And if you're worried about protection, we do have protection language later on in the document, so don't be concerned about that. But the cancellation also makes it easier. You know, we're going to have a representation agreement when we go out showing properties on the MLS. That's one of the requirements in the new proposed settlement. And as of August 14th in the Bright MLS, that's going to be a requirement. You're going to have some kind of representation agreement. So you may have just met a buyer that's doesn't know you from a soap stick. I mean, you just met them and you're asking them to sign an exclusive agreement with you. So this is designed so it could be for a short time. It's designed so it could be, as Andy said, for 1 or 2 properties, or it could be designed with maybe a 1-day cancellation provision. So trying to make it so it's palatable and that it can be doctored so that consumers will feel more comfortable using it. Now, then we're going to go to brokers' representations and services. And I'm not going to go over each of these A through I items here, but it says broker and or brokers designated agents must, as specified in the consumer information CIS statement, do, and it lists them. This is nothing new. We're not adding any obligations onto agents. This is verbatim copy and paste from the must category of the CIS. So we're just reiterating, here's the things that by Delaware statute, you must do. Now, there's some other things that you'll see in the CIS that says you may do, and some things that says you must not do. That's the confidentiality section. And a broker could, incorporate that language into a separate addendum or something if they wanted or chose to negotiate that. But we've put in here the things that we must do. These are the services that we must do. I'm going to then go down to the next highlighted section you see here. And as agents, this is something you want to remember. If two potential clients represented by the same designated licensee want to make offers on the same property. Now, we're not talking about two agents in the same firm. We're talking about one agent, a single agent, dual agent, the same person. Two potential clients represented by the same designated agent want to make offers on the same property. The designated agent shall disclose the situation to each potential client. In such a situation, broker and designated agents will not disclose to either client the terms of the other's offer. If either client does not consent to continuing to work with the same designated agents, then the broker shall assign another licensed real estate agent to work with that client's designated agent. So if you've got a buyer and seller, you individually are representing both, you disclose that, you're going to keep their offers confidential. But if they're not comfortable with that, they can go to the broker and they will assign another agent in the firm to represent one of the parties.
And Bruce, if I could pause you there, I hope this is not a surprise to you. This is, Delaware Statutory Licensing Act already specifically allows one designated agent, a single person to represent two buyers who are interested in making an offer on the same property, as Bruce has just explained. This then says that if that is coming about, you'll disclose that to each client. They can decide, hey, I'm okay with that, or they can ask the broker to go ahead and designate another designated agent within the company to represent one of the buyers for that offer on that particular property. So Delaware law already allows a lot of what Bruce has just explained.
So we point that out because we want to make sure that, I know this is mostly agents watching now, you're going to be dealing with clients and you want to make sure that you don't forget this. You will have a duty to make this disclosure if in fact you're representing two clients yourself individually simultaneously on the same property. Now, section 7, I'll just go over to D through F. I think the others were already in a prior agreement. D, for properties not listed in the MLS, client authorizes publication of the property and applicable disclosure attachments in the MLS after settlement occurs. So let's say it's a for sale by owner, or let's say it's not in the MLS, but you sell it as a buyer's agent. Once it settles, they're authorizing you to put that information in the MLS for comp purposes and for records. E, they authorize the broker to share pertinent financial information. We may have to share a financial qualifications or pre-approval letter or something like that. So during the course of the negotiations, it gives us approval to share pertinent financial information with other parties. And F, it authorizes us to put a sold sign on the property once settlement has occurred. So if a buyer hires you, they purchase a property, it's not on the MLS, it settles, we can put the information in the MLS, and once it's settled, we can put a sold sign up. I think everybody will like that. I don't think there'll be any argument over those provisions. Section 8 is disclaimers and limitations. This is sort of a cover ourselves and disclose to our client things like the A says that the client is advised that seller, landlord, and or their respective agents might not treat the existence, terms, or conditions of offers as confidential unless confidentiality is required by an agreement between the parties. You make an offer and it's presented to the seller. I know how we do business, but as agents, but the seller can go out on the golf course tomorrow and tell everybody out there, I just had an offer from Andy for X on my house yesterday. It's not confidential unless you have a confidentiality agreement. B, client is further advised that property shown to client may be monitored by audio or video surveillance equipment. I think it's wise, folks. Most of you know this. We put this in our listing agreement a couple of years back. Just assume when you're showing a property that the seller or landlord is sitting down the street in their car watching you and listening to you. because with all the nanny cams and the Ring doorbells and all that, there's a very good likelihood of it. So just be aware that if you say something in a house, your seller or landlord may hear what your tenant or buyer is saying. Client and C, client is aware that broker may not have knowledge of all properties that may be for sale. You hire me or some agent to represent you in finding a property to purchase. I may miss one or two of them. Not all properties are on the MLS. They may not be advertised. I might miss some. Then we go to D. Client is advised to contact a homeowner's or rental insurance company to obtain information and quotes. Just don't want sticker shock down the road or a problem. Hey, I can't get insurance. Flood insurance is going to be astronomical. I can't, go through with this transaction. Inquire about it now. Client F, clients advised to carefully review the seller's disclosure of real property condition report before making an offer. I can't stress this enough. I think a lot of agents don't even think about this. But if the seller's disclosure says that the dishwasher doesn't work, buyer doesn't check it because they say, oh, I'm getting a home inspection. Home inspector finds the dishwasher doesn't work. Buyer says, I want the dishwasher fixed. Seller says, forget you. I already told you the dishwasher didn't work and I'm not obligated to fix it. And you can't use it as an escape from the contract because you accept the property as it's disclosed on the seller's disclosure unless you state otherwise. Our contract says that currently. That's not new. Buyers need to read the seller's disclosure. I can't stress that enough. G, all properties are part of a larger surrounding areas. Client is advised to research federal, state, and local government agency websites and other sources to become familiar with future anticipated developments, global changes, climate changes, tax assessments, and other similar things that may affect the property in the future. This is just a real good disclosure and limitation. We're finding that a lot of the legislators, whenever something comes up and somebody complains, I didn't know about sidewalk maintenance, I didn't know about snow removal, they want to pass a law where you have to have a brand new disclosure. And so we've been able to head a lot of that off as an association by either incorporating those questions in our seller's disclosure or by language such as this warning people. And that way we don't need 10,000 forms to attach to our agreement of sale. So I think that has worked very well for us as an association. Now, here's the part where it gets a little bit more new, if you would. Compensation. You're going to find this next paragraph. You're going to have it memorized because it appears in every document we're going to show you. Client acknowledges that there are not any standard compensation rates, and the compensation in this agreement is fully negotiable, not set by law, any board or association of realtors, any multiple listing service, MLS, or in any manner other than as negotiated between the broker and client. Client should discuss compensation and the scope of services to be provided for such compensation options with broker or its designated agents. Broker can set their own compensation and fees based on what services are offered and their business model in the competitive marketplace. We have tried to be very careful to include all the buzzwords and all the language from the proposed NAR settlement and even the statement of interest in a PIN MLS case from the Department of Justice. We've used, for instance, the word fully. That wasn't in there originally. That was in their recommendation. We put it in. Bright said, hey, we want language to protect the MLS. We put it in. So we've been following this thing. And I think all the things that are going on around us, I think we've addressed them all until they change, which, as Andy said, could be sometime in the future. But right now, I think this is a really good document. And it works well, I'll show you in a second, with the new Bright rules that are going into effect. So here we go. 9A. Client shall pay compensation as follows. Select one. Now, this is the listing side of the transaction. You're going to either check compensation or you're going to check other.
I'm sorry, the buyer's part of the compensation.
Buyer's compensation.
Right.
So you're going to either check the first line compensation or the second one, other. How much are you going to pay your agent? So If I check compensation, I can put a percent. I'll pay my agent a percent of the gross selling price or lease, or I'll pay my agent a flat fee. That's what would go on that line after the word of, compensation of. And then you'll see at the end, it says plus dollars for services rendered. Some companies have administrative fees or storage fees of documents and things like that. So they'll charge additional fees. This allows for that. There's also a other. Now, you could have other models. You could attach a compensation addendum or rider that your company may have. You could put something else in here. You could charge, just by way of example, you could charge a retainer, non-refundable, with it being applied towards the purchase or towards the amount due. You could charge an hourly fee. You could do a lot of different, you could do a fee for services, a menu of services, if you would. What you can't do, and this is per the NAR settlement agreement, this is very clear. The amount of compensation reflected must be objectively ascertainable and may not be open-ended. It says language such as broker compensation shall be whatever the seller landlord is offering to the client is prohibited. That's what our current agreement says. That's why you want to throw that thing in a trash can. That's not the case anymore. The arrangement is the buyer or the tenant sits down with their agent. They negotiate what they're going to be paid, and that's what they're going to be paid. And if the seller or landlord is offering more, sorry, you can't take it unless you modify your written agreement with your client. You agreed to this, this is what you get. And I won't go, we could spend hours going into all the rationale behind this, but you will put in what you're going to charge. You will not be able to get more than that unless you have your written agreement modified. Now, the BCD, it says compensation may be offered from a listing broker or seller landlord.
Bruce, if I could pause.
Yes, go ahead.
There just for a minute. Could you go over the bold part there just before B, just before B? Client.
Oh, yeah. Client may include in any agreement of sale, lease, a request that the seller and landlord compensate broker all or a portion of the buyer's agreed upon compensation. And I thank you, Andy, because I don't want to miss that. That's why it's bold. It's important. We know that in A here, this is what the a buyer is agreed to pay us. But we also know that a lot of buyers don't have money in their pocket, additional money to pay the buyer's agent at settlement. If we were to say all buyers had to pay their agent out of their pocket or their financial capabilities at settlement, we would greatly limit the pool of potential buyers. It is possible that a buyer will hire an agent and say, I'm going to pay you X, and then turn around and ask the seller in the sales agreement, say, I've agreed to hire so-and-so for X, and part of my offer is you'll pay my agent X. That's included in my offer. I'm going to offer this, but part of the deal is you have to pay my agent on my behalf the amount that I agreed to pay him. I think you'll probably see that become fairly standard place. That's just my personal opinion. In fact, we've addressed it in the new agreement of sale. There's even a section specifically for that. If a buyer wants the seller to pay their agent as part of the offer, there's a section where they'll put that right in the new agreement of sale. See how that'll work? Okay. So B, compensation may be made from the listing broker or seller landlord. In such event, the compensation offered by the listing broker or seller landlord shall be credited against the compensation due from client. Should any compensation offered from the listing broker or seller landlord be less than the compensation due from client, the client's responsible for the difference. What we're saying is, if you hired me and agreed to pay me a basket of apples to represent you, and the seller said, I'm going to pay your agent a half a basket of apples, then guess what? You got to come up with another half a basket somewhere. Now, on the other hand, you'll see in here, and as per the settlement agreement, if I'm charging a basket of apples and the seller says, I'm going to offer you 2 baskets of apples, I still only get 1 basket of apple. Unless, and there's a form we've created, unless I go back to my client and tell them, hey, they're offering 2 baskets. I've done a wonderful job for you. Can I have it signed here? We've got a modification agreement where they would modify the amount that they're agreeing to pay you. But it's not one of these loosey-goosey things where I'll take whatever they give me, and if they give me more, I'm happy. Doesn't work that way anymore, folks. Those days are gone.
And Delaware law already is set up that allows that second basket of apples if the agreement between the buyer's agent and the buyer was that the buyer's agent's getting the one basket of apples, but the seller's paying two baskets of apples, that the buyer could get that second basket. Delaware law allows what otherwise would be compensation or commission money to go to a party in the transaction. So that could be that way as well.
So the buyer goes to their agent, they negotiate a compensation amount, and then if the buyer wants the seller to pay it on their behalf, they incorporate it in the offer of purchase and just ask the seller to pay it on their behalf. And that's all in the new agreement of sale. C, broker may bring available listings to the attention of client regardless of seller and landlord's offer of compensation. So we'll bring you all properties, not just those where they're offering compensation to buyer's agents or tenant's agents. And D, this compensation should be earned, due, and payable. This is just protecting us. If they turn around or if they purchase a property in the geographic areas that we've specified during the term of our agreement or any extension of it.
It's an E there.
In E, it's also due if after it's due upon settlement or possession, if they purchase a property after our agreement becomes null and void that we introduced them to. So we got a client, we show them a property, they use their one-day cancellation provision, they cancel the agreement and then go out and buy it and think they're going to save money. Nope, we've got a protection clause here, E. F, if not previously paid, the settlement attorney is hereby irrevocably authorized and directed to collect the compensation as specified in this agreement and pay same to broker at final settlement. Nobody's going to question that on our side. So G, if client enters into an agreement of sale or lease and that agreement fails to go to settlement or possession through no fault of the client, it just falls through. It wasn't that the client did anything wrong, then there will be no payment due. If it falls through because of some fault or defect or breach on the part of the client could still be liable. The fee would not be waived and they would have to pay it because they didn't do what they were supposed to. They were in breach. H, brokers shall not receive compensation in connection with this transaction from any other source unless otherwise specified and disclosed. And then it says other compensation models may be negotiated in Section 18. Section 18, you've got some room there to write, but if you want something more creative, like hourly or something, you'll probably come up with a company addendum, compensation addendum that you'll attach. And that's fine as well, too. I would tell you that what you want to do, we're not going to cover every word in this presentation today, and it's going to take you a second to digest some of it, maybe 2 or 3 seconds. You'll want to sit down and you'll want to read this document word for word. I tell in every documents class that I teach, I tell the students, you should read your document word for word at least one time every year. We're asking a client to sign a document that we're handing them. And sometimes I find agents don't even know what the document says. You should read it at least one time word for word. That's Bruce Plummer talking, not DAR. But you should read it word for word at least once a year. Now's a good time because they're all new forms. All right, we go to deposits. So that's your compensation. Buyer negotiates with their agent. If the buyer wants the seller to pay their agent on their behalf, they put it in the offer to purchase. Okay, not that complicated. Number 10, deposits. Client acknowledges that any deposits placed on account of a ratified agreement of sale or lease shall be payable, held, and refundable in accordance with the provisions of the agreement of sale or lease or a separate written agreement signed by the parties. We have this language in all of our documents now. It's just saying, you know, if people all the time want my deposit back, well, your deposit will be returned as the agreement says. Arbitration is a new section completely, and I think that's best handled by Andy, our legal counsel.
Thank you, Bruce. So this is an optional section. That's why there's the yes and no to check off. So you can basically explain to your potential buyer client, if yes is checked off on this, then you, the member of the public, and the designated agent and the broker and brokerage organization are agreeing that if there's a dispute between them dealing with this buyer agency agreement, not the agreement of sale, but with this buyer agency agreement, then that would be resolved by binding arbitration under Delaware law by a single arbitrator being the one to arbitrate the case. It would not be handled through class action litigation, like we're just being through now. So, but again, it's optional. That's why there's a yes or no. If a buyer wants to agree to that, agrees to agree to that, yes. If they don't want to agree to it, checked off no. You'll talk with your broker about what your company policy is about agreeing to that or not agreeing to that. And it would be handled under Delaware arbitration statute. So,
Okay. Thank you, Andy. Then we'll go to the CIS, Delaware Consumer Information Statement. It just says client acknowledges that the broker or designated agents have provided them a copy. They've read it and understand it. And the completed CIS is part of this agreement. The designated agent shall act in conformity with the relationship described in the CIS. This includes the designated agent being a dual agent. So the CIS makes it very clear under Delaware law. You can be a dual agent, an individual dual agent. That's not permitted in some states. In Delaware, it is. 22, agency relationship. We've just come up with a way to identify who the designated agent is. It says broker appoints, and this would be actually be, in this case, the agent working with the buyer or tenant client, the actual licensee, if you would. They're the designated agent. It does say that none of the other that they and their supervising broker will be agents for the client. None of the other agents in the firm are necessarily representing that particular client, but that the broker may appoint other designated agents to assist if the broker finds it necessary to assist, say the client, the designated agent's out of town or needs some help with something. And you'll see where we've got designated agent, we put agent and we put S agents. Because sometimes it may be a team and you'll list 3 or 4 names, and either or any of which would constitute delivery and authorized designated agent. Lastly, on this form, it says acceptance by broker or authorized representative. So we know some brokers require the agents to turn the form in and they sign it. Some brokers say, hey, you can sign it on behalf of the broker, provided it contains all the necessary ingredients in conformity with company policy. So it's the broker or their authorized representative. It does say it's not binding until it's signed by all parties, including the broker or their authorized representative. But that's the buyer agency agreement in a nutshell. And I think Wes is going to take a few questions on that before we go on to the next form.
Yeah, thank you, Bruce and Andy. We received many questions. So I'm going to focus around themes, if you will. I'm going to ask some specific ones that we've received. I should also note that some of these are very particular to probably what's going to be an office policy. So again, as we said at the start, please follow up with your broker if your question is not asked. So I'm going to go kind of in order as we receive them because they do go by theme. So Bruce and Andy, first one here. How will the buyer agent agreement impact open houses? If a random person comes in the open house who is not represented, is that considered more working for the seller? And if they want to see other homes, they would need to sign an agreement.
So I'll chime in on that first, and then Bruce can give perhaps a little more practical aspect of it as well. So Delaware Licensing Act and rules and regulations address open houses, and you need to have a CIS form just available there for somebody coming into the open house. Just like you probably have your seller's disclosure or your property description form available when they come in, have a pile of CISs there available as well. The Licensing Act and rules say you do not need to stop a buyer and go over that with them and have them sign that right then. They can walk around, tour the home, whatever. You don't have to make sure that they have gone over that CIS and signed it unless they are asking for more than factual information about the property or are expressing an interest in making an offer. Then you'd need to sit down with them, go over the CIS, make sure they understand, document the agency relationship then, whatever that may be then that they've agreed to. And go ahead, Bruce.
No, I agree 100%. And when you give them the CIS, they may choose to be unrepresented, which is fine. Or they may choose to be represented, which is the presumed status, in which case you could talk to them about a buyer agency representation agreement and what you would charge to represent them.
Andy, one of the questions that came in is there a new CIS? Do you want to touch on what's happening with the commission?
Yeah, there's not a new CIS at this point. It's the same consumer information statement. The Delaware Real Estate Commission is considering adding that paragraph that I showed you on one of my slides in the beginning. So that'll be within the purview of the Real Estate Commission. I know they're on top of this. They're aware of how things are changing as well, and they're trying to keep up with it, just like we're trying to keep up with it.
What about agreements that agents already have in place before this is implemented? Will there be required to amend agreement in their current paperwork?
I think that our next form that we create, we actually have a meeting scheduled in July. And that is to create a form which would be a modification to existing listings, existing buyer agency agreements, because our existing buyer agency agreement says we're going to take whatever the listing office offers us with a minimum of X. Well, it doesn't work that way anymore. It's got to be an ascertainable amount. And so I think that you could get a new agreement, but we're going to create a form that's just a very simple modification that just modifies those terms. And we'll make that available to everybody.
Just want to touch right back on the CIS real quick, Andy. Are listing agents required to have a CIS signed by an unrepresented buyer?
And the Delaware presumes that the person you're meeting with, you are representing. So if you're meeting with a buyer, you're the listing agent, if I'm following the question correctly, and correct me if I'm wrong, Bruce, but as far as the scenario, so you're meeting with a buyer, you're representing the seller, you're explaining then the CIS to the buyer and documenting whether that buyer is agreeing that you're representing them as well as a dual agent, assuming the seller allowed dual agency, or whether the buyer's checking off that they understand you're the seller's agent only. I don't know if I understood.
Yeah, and the CIS doesn't have to be signed when it's handed out, but it must be signed before they sign a brokerage agreement or make an offer to purchase. There's 3 events, I think, that trigger that where it must be signed. So before that, you could prepare an offer for them, even if they were unrepresented and wanted you to prepare an offer for them as the seller's agent only. They must sign the CIS before they make an offer.
All right, let's dive a little into the compensation more. How should first-time home buyers be counseled if their agent fees can be paid through their FHA loan?
I'm sorry, did you say can be or cannot be?
How should first-time home buyers be counseled if their agent fees can be paid through their FHA loan?
Well, I think that the FHA and the VA, from what I'm understanding, are going to allow a buyer to pay those fees, and the buyer can include them in the purchase price, have the seller pay them as a convenience to the parties. The buyer could pay them otherwise. And as long as the property appraises, I don't think that's going to pose any problems to those lenders. I think the VA, as Andy said earlier, has just recently come out and said, hey, we'll agree to that. In fact, I think the lenders are saying, we have limits on how much, it's 3 words, I forget, the seller concessions. We're not even calling that a seller concession. That's not even included in that total of seller concessions. So it's going to be permitted. You make the offer. If you want the seller to pay it, it's included in the price when they do the appraisal. And I don't think you're going to have a lender problem from what I can see.
All right, we'll do a few more here. Is an agent able to get a retainer deposit at time of signing buyer agreement?
Yes. If that's your company policy, that's your compensation model that you want to work on a retainer basis that way, then yes, that's part of this and part of the antitrust aspect of this, which I said Delaware law is already well set up for, that you can have all different brokerage models, brokerage relationships, compensation models, and we'll see how it comes out in the competitive marketplace.
And a little deeper into that one real quick, Andy, does the buyer agent have to disclose if they are paying a referral fee to another agent on the agreement?
On the agreement?
On the agreement, on the buyer agency agreement or on the agreement of sale? I don't think so.
Assuming this one.
No.
All right, if office policy, and this is specifically talking about rentals, is they only represent the owner and the CIS form indicates the relationship to the tenants is this form, the buyer tenant agency agreement, is it necessary?
So if you offered or gave the CIS to your tenant and you said, here's, typically I would represent you as a tenant's representative. That's their presumed status, but we don't offer that. We're not going to do that. So we're checking the box and saying, hey, we don't offer that. We're only a landlord's representative. And you did that, then the tenant consumer might say, okay, that's fine. And you would proceed, or they might say, oh, well, I want representation. Then they'd have to go somewhere else if you didn't offer that service.
All right, there is a section referring to time. Is it Delaware time?
Good question. I know in our sales agreement, we are very clear. Time is Delaware time. The days start tomorrow and they end at midnight. We were very, very clear. I think that's the intent.
All right, do you have to get a new buyer's agency agreement signed if you had one signed this month prior to the new one?
And once again, I think you could, but you don't have to. You could do a modification. I just wouldn't stay with the language that says, hey, we'll take whatever they offer us with a minimum of. I would do a modification to that. And that's the form we're going to create in July and make available to everyone.
Does this also cover short-term rentals?
Well, short-term rentals are of course exempt from having to give the CIS out if they're 120 days or less non-renewable. Let me go back to the question. Oh, so you could represent a tenant in a short-term rental scenario, or you could say, I don't offer that service. And if you don't offer that service, certainly the tenant could go get their own agent if they chose to do so.
Let's talk about builders real quick. How does it work with open houses and builders with your buyers?
This is a question that comes up a lot. Some builders will say, we're going to pay you a basket of apples. And then if you sell a second home, we'll pay you a basket and a half. And the third home, we'll pay you 2 baskets, or they'll have a bonus or something like that. The settlement agreement with NAR is very clear, and our documents are very clear. You can only take what you negotiated with your client, your buyer or tenant client, no more. So if they're offering more, you would advise your client of that, and your client could take it as a concession or reduce their price accordingly or do whatever they want in their offer. The only way you could ever get more is to go back to your client, have the discussion, and get them to agree to modify your compensation in a form that's the next form we'll talk about, a modification agreement to buyer agency.
Yep. So remember, everyone, we do have some other forms this will go over today. There's definitely quite a few questions that have come in. A lot of these, honestly, are broker discussions. So please contact your broker. We did have a training for all of the brokers within the association last Thursday. So we did go through the forms and discuss them with them. I just want to ask a couple more, Bruce. If buyer terminates, so 9E, if a buyer terminates agreement with broker A, then goes to listing agent, which is broker B, signs a new buyer agency agreement, I would presume broker A's commission is not protected.
Well, in our listing agreement, that's the case. You're protected unless they've retained another agent. That is not the case here in our buyer agency agreement. There is the protection period would still apply, and it was intentionally done that way. So a buyer would want to make sure that their next agent knew the properties that they had already seen with another broker.
Andy, will settlement companies be required to receive a copy of this buyer agency agreement so they approve the compensation owed?
The settlement agent could ask for a copy of this, or could just take a email or direction as to the compensation being paid. So it doesn't have to be this form itself. Now, if you had a buyer who was trying to say to the settlement agent, well, no, I don't want you to pay my buyer agent as part of the settlement, then the buyer agent could present this form that has the paragraph in it to say that the buyer is authorizing the settlement agent to pay that money.
And we're going to conclude this with one more question here. Again, if you do have further questions, feel free. I'll put our email address into the chat. We'll try to tackle the ones that were not covered during this session. The last one here is, what happens if a buyer unknowingly signs a buyer agency agreement with more than one broker? Without a database or anywhere to register these agreements, we have no way of knowing what buyers are already in contract with another agent.
I would say that would be rather careless on the part of the buyer client to do that, or reckless. But remember, in our code of ethics, we have an affirmative duty to verify that they have not entered into and are not subject currently to an exclusive agreement for the same services. Different services would be fine, like they hire me to do the sale and they hire Andy to do the rental. That's fine. But I need to ask, are you currently under an agreement with anyone else? And if so, is it exclusive? I have an affirmative obligation in the code of ethics to make that inquiry.
And by the way, they couldn't hire me because I'm not like a broker. So they would have to hire you as a member of the audience here today.
Bruce, real quick, before we go to the next form, I do want to just remind everybody, we're getting comments through a bunch of different accounts. Only send your comments to where it says to. Scroll down to questions with a question mark. That's the only place we're going to get the questions through, and we're going to look at and then ask them. So please don't send it to like the Delaware Association of Realtors, Matt, Bruce, Andy. We all have accounts up, so only send it to questions. Bruce, go ahead.
So the next form, I'm not even going to bring it up in the interest of time on my screen. I'm just going to tell you, you've probably got a form called a modification to buyer / tenant agent representation agreement. It's just like a modification to our listing agreement. You can change the expiration date. Maybe you want to extend it. Maybe you want to cancel it today. So you put today's date. And you can also change the compensation. Maybe you agreed to X, but now you find out more is available. You've discussed it with your client. Your client says you're wonderful. I want you to have it, not me. And so you do a modification. Or then there's a blank.
Well, there's less available.
Yeah, they're less available. And then there's a blank for any other time. So it's just a simple modification to your buyer agency agreement. The next big agreement is the listing agreement. And I'm going to once again share my screen. What you got a picture is the buyer meeting with the buyer's agents, negotiating between the two of them what they're going to pay. If in return they want the seller to pay it on their behalf, the buyer in their offer, and there'll be a place for them to do that, will say, as part of my offer, you agree to pay my agent X. We know that come August 14th, Bright MLS, these are the things we know. When you go out to show a property on the MLS, you will need a written agreement with your client. We know that the MLS will no longer offer any compensation to buyer or tenant's agents, period. And you can't play games with that. The violations are serious. Bright MLS said, hey, we've got somebody said, we're just going to put pillows on the couch when we do our staging photos and put the photos in the MLS, and we'll put a little number on there what we're offering. No, it's not going to work. There is no offer of compensation being made in the MLS to the buyer or tenant's agents. That is contrary to the settlement agreement and will get you in serious trouble. Now, even though the NAR proposed settlement would allow a broker to communicate an offer of compensation broker to broker or on their website, not on the MLS or any other showing time or anything like that. Even then, they're so limited. You're going to find in this listing agreement, we not only tried to do the listing agreement to satisfy the proposed settlement of NAR, we decided to go all the way, folks. Let's not play games with this. We really have been following the Department of Justice. They've made their position very well known. We're going to rip the Band-Aid off and we're going to do it the way they want it. In fact, I just heard today from Andy, there's another state just did the same thing. And we did that because we thought it was good business, number one. Number two, from what we've been reading and seeing, associations and states with standardized forms that allow for compensation of buyer's agents being discussed and negotiated by the seller or landlord are opening themselves to lawsuits. You know, they've already gone after NAR and some of the big brokerages. We're next, folks, if we try to play games with stuff. So we've tried to go all the way to the extreme end. This document hopefully will last for a while and will stand the test of even the Department of Justice, what they're currently saying.
And let me pause there for you, Bruce. And actually, I think in a lot of ways, if you read the DOJ statement of interest in the PIN case, the no select case from Massachusetts. If you don't have it, send me an email. I'd be happy to send it to you. I studied that. I thought about it a lot. It's actually in a lot of ways it's easier because then within your listing agreement, you're discussing compensation with the seller. The seller doesn't have to agree to a dollar amount or a percentage of seller concessions at that point. You could just say that's a possibility. A buyer may make an offer requesting compensation. You could just use this listing agreement to just check off, yes or no, that the seller would consider that. So they check off yes. They don't have to fill in a dollar amount or a percentage if they don't want to, and basically bring an offer. So what you're saying, if you're checking off yes, you're just saying, hey, between listing agent and seller, we don't have to talk about this anymore. We don't have to talk about the amount. We don't have to talk about the percentage. Just here's the concept. Be aware that buyers may make offers requesting compensation. And that's specifically in the DOJ statement of interest in that PIN case. They put right in there that the buyer may make an offer to the seller requesting the seller to pay compensation. So in a way, in my view, it's actually easier to not have to have a whole conversation with the seller about how much will they pay, how much would they compensate in the way of compensation or seller's concessions. You could just say, well, yes, will you consider an offer with seller concessions? Well, yes, I will. We don't have to talk about the dollar amount. That's between the buyer and the buyer's agent. Let them talk about compensation. Buyer, just make your offer accordingly. That's can end up pretty simple to do it that way. And then you're not having to try to look at a listing broker's website. You're not having to try to call a listing broker and find out is their seller willing to do seller concessions or in any way. Just make the offer.
Yeah, can you imagine going from broker website to broker website, calling broker? What are you offering compensation? How much? And going, just make an offer, include it in the offer, and it becomes a negotiable term.
Yep.
So this is the new listing agreement. It's an exclusive agreement, just like it's always been. Exclusive right to sell listing agreement. And once again, we've got the brokerage organization, the name of the firm, and we're identifying them as the listing broker. Now, we came down and we put the included items here. What we did is we incorporated or added the electronic smart doors, smart cameras, doorbells, smart thermostat, backup generator, and we made it mirror the new seller's disclosure. That's all we did. We made it so all the forms look the same. And of course, the seller's disclosure, we don't control. We made recommendations, but that's a real estate commission form. All right, so once again, we've got an expiration. We've changed that to read expiration. Now, here's where we're going to get to the fun part. You're sitting down talking to a seller, listing their property for sale, section 10, compensation. Remember I told you you'd memorize this first paragraph? There it is again, verbatim, word for word, with everything that everybody could possibly want. Now, 10A, listing broker compensation. Here's where you need to understand what this is asking. This is asking, how much are you charging for the listing side of the transaction? Not the whole transaction like you asked before. We say, you'll pay us X and we'll split it this way, that way. How much do you want to represent me on the listing side of this transaction? And that's where you're going to put in a percentage or a flat amount plus any other fee if you have another fee. And it says seller acknowledges that buyer may choose to be unrepresented. There may be some buyers who say, I don't want representation. I just want to make an offer. I'll represent myself. Okay. Well, we know as agents that they may not have representation, but that means more work for us. We've got to prepare the document for them. We've got to explain things to them. We've perhaps got to schedule inspections and things. It's a whole, we're doing both sides work. And yet there's only one agent involved in the transaction, the listing side. So if a company were to choose to want additional compensation for that, which they very well may, if the one agent's handling it all, it's more work for them. But what if it's another agent in the same firm? Unrepresented buyer, how are they going to get paid? This is how they would do it. The first paragraph is, here's what I charge for the listing side. The second paragraph says, hey, if the buyer's not represented and there's no buyer's agent, that means more work for me or somebody in my office. We're going to charge an additional fee. Now, you don't have to, but it's there if you choose to.
Now, Bruce, what if it was within the same company, but it wasn't the listing agent who was doing that additional work. Within the company, there was a different licensee who was a buyer's agent. Then that would not be this situation.
That would not apply in that case because this says an unrepresented buyer. If the buyer's working with another agent in the same firm and that buyer retains that agent in that same firm as a buyer's agent, then they're going to sign a buyer agency or buyer representation agreement, the form we just went over, and they'll negotiate what they're going to pay on that side.
Thank you.
So the first paragraph would be the listing side. Whatever they negotiate separately is what would be paid for the selling side.
Got it. Thank you.
Next, B, buyer's broker compensation. Seller acknowledges that offering compensation to a buyer's broker is not required by law. It's not. Buyer broker compensation may be discussed during negotiations at any time an offer from a buyer is received. Now, the NAR proposed settlement would allow us to put language in there, but we've just gone with what we think the Department of Justice is instructing us to do, and that is we're not even going to talk about it. Make an offer. Negotiate that with your buyer's agent, and then if you want the seller to pay all or part of it, put it in your offer. Other compensation models may be negotiated in Section 25, additional terms, or by separate addendum. All compensation specified above shall be doing as specified above in the event subject property sold, conveyed, or otherwise transferred by a seller within blank days. This is our protection period. And you'll see in the listing agreement, it says this provision does not apply in the event the subject property is listed with another broker at time of sale. That's always been in our agreement, or at least for the last 20 years. And here's our language that we like. If not previously paid, the settlement attorneys directed to collect it at settlement. If you get into a dispute and buyer says, well, I'm not paying it, the attorney says, well, I can't settle because I'm authorized here to collect it, and I'm going to collect it, irrevocably authorized to collect it at the settlement table and pay it per your separate agreements. Now, we know the MLS no longer offers buyer, broker, or tenant broker compensation. But the MLS will have a new field. It's available now, and it says seller concessions. We know that if a buyer's buying a property, they've got a lot of expenses. You know, our transfer tax is certainly the highest in the country. We understand that. If they've got to pay a buyer's agent out of their pocket, that's more money. They've got surveys, title insurance, title search. It goes on and on and on. So what a seller can do is they can say, hey, I'm going to offer a concession. You know, now all these buyers across the country are going to have buyer's agents. They're going to have to pay their agent something. They're going to have to do this. They're going to have to do that. It becomes very cumbersome. We'll offer a concession. This is not a buyer broker fee. Don't call it that. This is a seller concession. It can be used for anything the buyer wants. Now, they may use it to apply towards their buyer agency agreement to pay their buyer agent, but they can use it for whatever they want. It's a concession, not a buyer broker fee. The neat thing about this is Bright's MLS does allow you to put this information in Bright. And it says seller concession may be offered by seller to assist buyer with closing costs, but are not required. Seller authorizes the listing broker to market seller concessions to be paid at closing with an acceptable offer, yes or no. And you can do that in the MLS, as Andy was saying earlier. Just put yes. You know, I'll consider some concession. Bring me an offer. You could even, if you go to the next page, it's got optimum or optional amount to be offered. You could even put an amount in there. I'm going to offer a concession of X% or some flat fee or whatever. But you don't have to. But this allows you to put concessions in the MLS that you're willing to consider it in an offer. And even if you want to, how much you'll pay. And that information is able to be in the MLS and is published. So a buyer will know that that's available to them for an acceptable offer. Authority to cooperate with other brokers. In Delaware, we're required, per the Code of Ethics, required to cooperate with other brokers unless it's not in our client's best interest. But then it says, do you authorize the listing agent to cooperate with brokers who are sub-agents of the listing broker? And that's a yes or no. If they're a buyer's agent, we're going to cooperate with them. If they're a sub-agent, are you going to cooperate? Yes or no.
The reason for that with yes and no is liability reasons. And in a little bit, this is kind of back to the future because we kind of thought seller sub-agency was going away because of the liability that a seller has if there's a sub-agent who's working with a buyer, but actually being a sub-agent of the seller. But that might come back into play a little bit more now under the scenario of business being done. So that's why we put a yes or no for the seller to actually consider that. Are they going to allow seller sub-agency with that liability that comes along with it?
Now, under the section 14, disbursements of deposits, we said that if the agreement of sale provided by DAR is used for the transaction, then the seller agrees to the following process for dispersing of deposits unless modified in the agreement of sale. So it says, provided we use the DAR form, sales agreement, here's how the deposits will be returned. And what we said, because we know in some cases, in fact, in the new buyer, our new sales agreement, there'll be a provision. Is the listing office holding it or the buyer's broker holding it? Or it could be, and we're starting to see more and more, where title companies or attorneys are holding it. Somebody else is holding it. If it's a Delaware brokerage organization, a licensed brokerage in Delaware, regardless if it's the listing broker or the selling broker, makes no difference, buyer's broker, I should say, they can disperse under these conditions, where before it used to just say the listing broker may. Now either broker may. We call either broker the escrow broker, the one that's authorized to hold the funds in the agreement of sale. However, that's not the case if a non-broker is holding it, such as an attorney. We'll talk about that in a second. Everybody's familiar now, hopefully, with the passage of time disbursement option, where if there's a dispute, rather than hold the deposit forever and ever and ever and ever, because you can't get a mutual release, the broker can notify the parties, hey, time has passed. This doesn't seem to be getting resolved. You either notify me that you've started litigation, arbitration, or mediation. And if you don't, within 60 days, I think it is, then I'm going to go ahead and disperse it to the person that I think is entitled to it. That doesn't take your rights away. You can still go to court and, sue for it, but I want to get it off my books as a broker. Well, it used to say the default in that first line, the default used to be 180. We're finding that brokers are saying that's too long. So the new default is 60. Now you can put whatever you want in there. There's brokers I've heard that are putting 10 days, but that's entirely up to them. But the default will be 60 days now instead of 180.
And the broker's not obligated to make a decision who they think should have that return of the deposit money based on the passage of time. It's optional.
Yep, solely in the broker's option.
Right.
The language here about deposit held by non-broker, this is if it's not a licensed brokerage organization. If an attorney were holding it, then you'd have to have a separate escrow agreement. And we said the seller understands that disbursements of deposits not held by licensed Delaware real estate brokerage organizations, and we're not necessarily recommending that, we're cautioning here, are not necessarily done in compliance with the language set forth in this section. In such instance, sellers is advised to consult with legal counsel. A lot of people say, well, I'm just going to have the attorney hold it. Well, what if after the agreement's signed, the attorney does a search and finds out there's a conflict of interest and they can't represent them or hold it? There's a lot of pitfalls to attorneys holding the deposit, but that's not for me to decide. That's for the parties to decide and the brokerages. But we have put that warning there, if you would. Now we're going to go to authority. It says in section 18, if the agreement of sale or a separate escrow agreement directs a party other than the listing broker to hold escrow deposit, this is like if the attorney is holding it, the seller authorizes the party holding the escrow deposit to disperse any compensation due to the listing broker resulting from a forfeited deposit. There's provisions where if the parties breach the agreement and the deposit's forfeited, we're still entitled to our fee up to but not to exceed the amount of our original compensation. We're entitled to half the deposit up to but not to exceed our normal compensation. Well, this just gives the authority to disperse that to the listing brokerage. Say, if, for instance, somebody else is holding it. Fair housing, you're going to find this in all of our new documents. Rather than just naming the protected classes, we named the current ones, and then we said if there's any other ones added or changed, it applies to any protected class, as may be from time to time added or amended. Buyer supplemental offer letters. These are your love letters, if you would. Oh, sell to me because I've got a family of 3 and my kids are going to love the backyard. Well, this could cause these, the seller could look at these and could make a decision on who to sell to or not to sell to, based on a protected class that might land them in serious trouble violating the law, fair housing laws. Now, some people have said, we're not going to present buyer love letters. I know some states have said that's their directive. I know that was challenged. I believe it was California or somewhere out west. Oregon. And they said, hey, that's an infringement of your rights of speech. So we're not trying to say that you can or will or won't. What we're saying is we're cautioning the seller. Buyer supplemental offer letters involve common practice among buyers and their agents of attaching a personalized letter to their offer, aiming to sway the seller towards accepting their proposal. These letters might contain details related to a buyer or seller's protected class or characteristics. Making decisions about accepting an offer based on such protected class or characteristics is illegal. So we're cautioning the seller here. If you're going to look at these, you better be careful. It's against the law to base decisions based on protected classes.
And you'll want to talk with your broker or your broker manager about this, because some companies have a company policy saying they will not present a buyer love letter until after the contract's negotiated, fully ratified and everything. And then if that was the buyer that was successful and they had a buyer love letter, that they would deliver it at that point to the seller. So many of these things, this is one of the areas you'll discuss with your broker.
We also added in our standard addendums a coming soon addendum. We don't have the addendum prepared yet, but we decided we were going to make one. Well, actually, we may not even need one now because Bright has changed their policy in one of their forms. It's going to be required in August, I believe. And so that may eliminate the need for this, but that was something that we had planned on working on as a coming soon addendum. So the seller realized what they were doing when they said, hey, yeah, let's list it coming soon. Mr. Seller, do you realize that means we can't show your property, period, under that status? We've got our arbitration language.
Right. Same as we discussed with the buyer representation agreement, same optional arbitration, binding arbitration language. There, that was simple, wasn't
it? And then we've got the same thing here about the broker or authorized representative, except in this document, we said this agreement is binding once signed by all parties, including the listing broker or their authorized representative, even though the marketing or MLS entry of the property may not start until a later date. So maybe we don't want it shown, we want it in coming soon or something like that, but we've got a signed agreement. So once we get the agreement signed and we go out and start getting pictures and staging and virtual tours and all that, this agreement's binding, even though you haven't said, yeah, put it on the MLS as active and able to show yet.
And I think you explained a little bit before, Bruce. I don't know if you want to flesh it out further, but that this works well with the new Bright form.
Yep. Because
they can allow a longer period of time. Is
that coming soon used to be limited to 21 days. That is no longer the case. There is no limit on it now. But you have to have a date that you put in the form, the new Bright addendum. But it's not 21 days or 30 or 40. It could be whatever you were parties agree to.
So if I was listing my home for sale with you and you said, Andy, this place needs some work. And I said, well, this is going to take me 60 days to get contractors in here, do the work, do the painting and everything. We would still have a binding listing agreement.
Correct.
I would know you're my listing agent. You would know you're my listing agent.
Correct.
And I would have that 60 days to.
And I think agents wanted this because agents go out and start spending their own money, getting virtual tours and pictures and aerial photography. And then the seller says, well, the marketing hadn't started yet. I'm just canceling it or withdrawing it and we're out the money. So this was to protect our members.
And that works well with the new Bright form. Good.
And that's the new listing agreement. So the buyer negotiates the buyer agency agreement with their agent. The seller negotiates with their agent what they're going to pay them. They can offer a concession if they choose. They don't have to. The buyer can ask that the seller pay their fees on their behalf if they want to. Seller's not obligated to. Seller looks at the whole offer, looks at the bottom line, compares offers, and decides which one they want to take or they negotiate.
Wow, Bruce, that was a very good, simple explanation about how the marketplace can really work.
from Mars as you know, it may seem. It can work. It can work.
All right, ready for questions?
Sure.
All right, if we have a seller with their home listed with the old listing agreement, and that is still in the market when the Bright change takes effect, do we have to get new listing agreements signed?
I think that's a good question. Now, the NAR proposed settlement would allow you to continue to offer offers of compensation to a buyer's broker, but it's not in the MLS. It's very limited where you can do that. So you could do that, but your seller may be thinking it's in the MLS. So you may want to get a new listing agreement, or you may want to go back and get a modification to your listing agreement, just like we're proposing for a modification to our buyer agency agreement, just so the seller knows exactly what you're doing and that you're in compliance.
Bruce, if you could scroll up to number 10, please. This is a statement that I believe is supposed to be a question. So I'm going to read it once it's up there. All right, it is 10A1 indicates that the commission is earned with an acceptable contract. It doesn't say that it's only due if settlement occurs.
Yes, that's intentional. Out west, and we're finding more and more of this, and this may change in Delaware at some point. I mean, Andy may want to weigh in on this, but a lot of places they're saying that compensation is only due if it goes to settlement. Well, we've always taken the position that our fee is earned when we find a party ready, willing, and able to purchase under the terms and conditions of our listing agreement, and that we've earned our fee. And it may or may not settle if the buyer breaches the agreement. We've earned our fee. So it does read just like this statement said. That is not the case in some jurisdictions. It may change here, but we've left it like it is. This is like our current agreement reads.
Right. And if a seller wants to say that it's only due and payable if it goes to settlement, they could write that in the additional terms.
I've seen banks on bank-owned properties sometimes incorporate that language in one of their bank addendums. Yeah. So don't be surprised if you see it, but that's not in Delaware yet.
All right, if you could go to number 11. Section 11 says acceptable offer. Who determines that?
The parties.
Yep.
All right, next one is what happens if the offer of compensation from the seller is less than the compensation in the buyer agency addendum?
Okay, that I can give you a real clear answer on that. Let's say I've got an agreement with a buyer and they're going to pay me a basket of apples. The seller only offers me a half a basket. The buyer's got to come up with the other half somewhere. They've got to supplement that or bring the rest of it to the settlement table, or they've got to try to negotiate it somehow in the sales agreement.
And the buyer's agent not require the buyer to make up the difference?
The buyer could waive it. Certainly you can reduce your commission now. Nothing will prevent that from happening.
When will these forms be available to use? The forms are being uploaded as we speak. They will be fully available to the membership on June 28th. Okay, the next one is what if the seller wants to compensate a buyer's agent? Do we need an addendum to the listing agreement?
If they want to, in the listing, if they want to offer compensation to a buyer's
No
agent,
concession.
they could use the concession. Okay. Or they could, for the NAR proposed settlement, they could attach an addendum and do that. But the Department of Justice doesn't like that. They've made it very clear they don't like that. You'd be better off to use the concession field.
So let's talk about the effective date and kind of timing overall. We're going to have these forms available. When can they actually use them? August is a specific date and time also. How does that play in?
Well, I think the MLS rules, I think August 17th is the trigger date, but Bright has said August 14th, I believe, is when these things will be required. These forms will replace the current forms on June 28th. So if you go signing into the database, the Delaware Association Realtors website, and look under forms, you're not going to see the old ones anymore. You're going to see the new ones as of next Friday. Doesn't mean any current agreements aren't fine. You know, that'll be fine.
All right, I actually went through all those questions for this form.
Okay.
We can conclude if you have any final thoughts.
It's really not that far-fetched. What the Department of Justice wants and what the lawsuit was brought about by, they want the buyer negotiating with the buyer's agent. How much am I going to pay? The buyer might be able to get a better deal that way, rather than the seller and the seller's agent negotiating it. in which case the buyer's agent doesn't have to really negotiate it. They'll just take, oh, you're going to give me this, I'll take it. And it could be more than what the buyer wants to pay, and the buyer may have suffered financially because of that. And so the buyer will negotiate with their agent, the seller will negotiate with their agent. If the buyer wants the seller to pay their agent's fees for them, nothing will prevent that. Put it in the agreement of sale.
And I would just say, have confidence in yourself. Okay. It takes study. It takes some quiet time thinking about it. As I mentioned before, think about your own value proposition and why a buyer would want to hire you as a buyer's agent. Seller would want to hire you as a listing agent. And by all means, be keeping clear lines of communication with your broker, your office manager, so they can help you through and understand all this. Do some role playing within your office so you can think more and see how you're going to be discussing this with buyers and the sellers. And I have confidence you can do it.
All these forms are really designed to comply with the lawsuit and proposed settlement and Department of Justice, and they're all for our benefit to keep us out of trouble. And role play, I recommend you do role play. I recommend that you're going to have to improve your value proposition. We're real good at going out and competing for listings where we tell a seller why they should hire us. We need to get better at going out and talking to buyers why they should retain us. We need to do a better job with that.
And that's what I mentioned before. I think overall, it's going to elevate the level of professionalism within the real estate brokerage community. I think that's good. I think this is going to be good for members of the public. And I think we can work with it in Delaware.
I read an article a day or two ago, Andy, where about 70% of agents in the country don't like the settlement agreement. 68% of consumers do. So they're the boss. This is the way it's going.
Just a note for everyone's calendar. So we are finishing up the agreement of sale. The member session that we have scheduled for that, so please mark your calendars, is July 18th at 2:00. Again, that's July 18th at 2:00. Now, Bruce and Andy, I do have a couple more that have come in that quick couple minutes there. Is it okay to go through a couple more? Just for everybody to know, we've concluded the overall presentations. We're going to do a few more questions and go from there. Okay, do we need an addendum for the compensation field when the compensation field goes away?
Yes, you will no longer be able to, when you go to show a property, there will no longer be an offer of compensation within the MLS. So Bruce, if you want to.
Yeah, that field won't even exist in the MLS. You won't be able to input anything. There won't be any box to input it in. It'll go away come August 14th.
Good question here. Should there be a confidentiality clause in the listing agreement?
That's something you may want to recommend to the Forms Committee. We made a disclosure about things aren't confidential unless you have a confidentiality agreement, not confidential on non-members out in the public. Something we could look at. In fact, we've got a whole list, believe it or not, that we've not been able to get to because of all this for the last 8-10 months. But we've got a whole list of forms that we're working on, like a as is, where is, a mobile homes on lease park addendum, all these things. And one of the ones we talked about was a confidentiality agreement.
Would it be out of order for a seller to require a copy of the buyer's agency agreement?
I guess what they're asking for is verification of the compensation terms. Would that be what you think?
Yeah, maybe they want to make sure that they're not offering more than what the agreed amount is with the buyer's agent. I mean, they could certainly offer it. I don't know that there's any obligation to provide it.
Right.
Or you could certainly redact it and provide a part of it, maybe. They can ask anything they want. That doesn't mean you have to do it.
All right, we made it almost 2 hours later. So thank you to all the members that stuck with us, to all 267 of you. We appreciate you joining us. Again, if you have further questions, we can try to answer them if you email us through info@delawarerealtor.com. Again, save July 18th as the next session to learn more about our new agreement of sale, which we are finalizing the details on. And that's everything for today. So thank you all again for joining us. Have a great day.
Thanks, everybody.